If you are a naturalized United States citizen, there is a strong chance that over the past few weeks you have come across headlines or social media posts suggesting that U.S. citizenship is no longer secure. Some posts go as far as claiming that thousands of citizens are about to lose their status, while others imply that a new policy has quietly changed the rules overnight. For many immigrants who spent years navigating the legal system to become citizens, this kind of messaging hits a deep emotional nerve. Citizenship represents stability, belonging, and safety. So when that status appears to be under threat, even indirectly, anxiety spreads fast. The problem is that fear travels much faster than facts. And right now, fear is doing most of the talking. To understand what is actually happening, it is important to separate political noise, media framing, and legal reality. These three things are often treated as if they are the same, but in practice they operate very differently. Let's start with the legal foundation. U.S. citizenship, once granted through naturalization, is not conditional. It does not expire. It is not reviewed annually, and it is not subject to cancellation based on changing political priorities. The only way citizenship can be taken away is through a formal legal process called denaturalization. And that process is far more limited than most people realize. Denaturalization is not a new concept. It has existed for decades and has been used sparingly across multiple administrations, regardless of which political party was in power. The legal theory behind it is simple. If citizenship was obtained through serious fraud or intentional deception, and that fraud was central to the approval of the application, the government can ask a federal court to revoke it. That last part is crucial. This is not an administrative decision. It is not handled by an immigration officer behind a desk. It is not something triggered by a database scan or an automated system. Denaturalization cases are filed in federal court, argued by Department of Justice attorneys, and decided by federal judges. This alone places a natural limit on how many cases can realistically move forward. Yet, despite this reality, recent headlines have focused heavily on one specific statistic: claims that denaturalization cases have increased by as much as 16,000%. On the surface, that number sounds dramatic. It suggests an explosion of cases and an aggressive shift in policy. But numbers, when removed from context, can tell a very misleading story. For many years, the number of denaturalization cases filed annually was extremely low. In some years, it was fewer than 10 nationwide. When you start from such a small baseline, even a modest increase produces a massive percentage change. Going from 10 cases to a few hundred cases creates a percentage that looks alarming, even though the actual number remains tiny in comparison to the overall population. There are currently more than 25 million naturalized citizens living in the United States. Even at higher recent filing levels, denaturalization affects a fraction of that population. It is statistically insignificant for the average citizen, but statistics do not generate clicks. Percentages do. Another key point that is often missing from these discussions is how selective the government must be when deciding which cases to pursue. The Department of Justice does not have unlimited capacity. Each denaturalization case requires extensive investigation, document collection, legal review, and court litigation. These cases often involve events that happened 10, 15, or even 20 years ago. Records must be located, witnesses interviewed, and evidence reconstructed. This process takes time, money, and skilled legal labor. As a result, prosecutors focus almost exclusively on cases where the evidence is strong, the fraud is clear, and the legal theory is likely to survive judicial scrutiny. Marginal cases are usually not pursued at all. There is also a common misunderstanding about what qualifies as fraud in this context. Fraud does not mean making a mistake. It does not mean misunderstanding a question. It does not mean receiving incorrect advice from a lawyer. It means intentionally lying or concealing information that would have changed the outcome of the case. For example, failing to disclose a serious violent crime, hiding involvement in persecution or terrorism, or fabricating the basis of an asylum claim. These are the types of facts that courts consider material. Without them, citizenship would not have been granted. That causal link is essential. By contrast, minor discrepancies, old traffic violations, or administrative errors do not meet this standard. Courts have consistently rejected attempts to revoke citizenship based on technicalities or harmless omissions. The legal system recognizes that immigration processes are complex and that human error exists. It is also worth noting that even when a denaturalization case is filed, the outcome is far from guaranteed. The government carries the burden of proof. Prosecutors must show not only that a false statement was made, but that it was intentional, material, and decisive. Defense attorneys can challenge evidence, question witnesses, and argue that the alleged misrepresentation did not affect the final decision. Federal judges approach these cases with caution. Citizenship is considered a fundamental right, and courts are reluctant to strip it without overwhelming justification. This judicial hesitation is not a loophole. It is a safeguard built into the system. Another source of confusion comes from the assumption that denaturalization automatically leads to deportation. In reality, these are separate legal steps. Even if citizenship is revoked, additional proceedings are required before any removal action can take place. Each stage involves its own legal standards and opportunities for defense. So why does the public conversation feel so urgent and intense right now? Part of the answer lies in politics. Immigration remains one of the most polarizing issues in the United States. Strong language energizes supporters, even if it oversimplifies reality. Media outlets, especially online platforms, often amplify that language because it drives engagement. Another factor is the role of social media, where complex legal processes are reduced to short clips, captions, and emotionally charged summaries. Nuance does not survive well in that environment. For many viewers, the result is a sense that something sudden and dangerous is happening behind the scenes, when in fact the legal framework has remained largely unchanged. This does not mean people should ignore the issue entirely. Awareness is healthy. Understanding how the law works is empowering, but panic is not productive. If you are a naturalized citizen who knows there were serious issues in your past immigration history, consulting a qualified attorney is a reasonable step. That does not mean you are in danger. It means you are being informed. For everyone else, there is no evidence to suggest that ordinary citizens are at risk. Citizenship is not being quietly dismantled. It is not being reviewed en masse. And it is not being revoked based on political mood swings. The system is slower, more constrained, and more cautious than headlines would have you believe. In moments like this, the most important thing viewers can do is slow down, verify information, and resist the pressure to react emotionally. Law operates on evidence, procedure, and precedent, not on viral narratives. Understanding that difference makes all the